Okay, everybody, why don't we get started? Welcome to this session on what it means to have a fiduciary duty. My name is Arthur Labey. I'm very pleased to be moderating this panel. Let me just very briefly introduce my co-panelists. So to my left is Mitch Gibbons, who is General Counsel and Chief Legal Officer of Fayez, Seraphim and Company. And to my far left is Bob Plays, who is a partner at Proskauer Rose. But that doesn't really tell their whole story. Let me just very quickly add that I know both of these, my co-panelists personally very well. Mitch and I were colleagues at a law firm some years back. She truly has an excellent reputation in the financial services area. And I can say from my knowledge of Bob that he's really one of a small handful of truly superb national or international experts in the area of advisors and the Advisors Act. So I'm really delighted to be here with both of them. So let me just quickly go through our agenda. I am going to give the world's shortest introduction to fiduciary duty, and I truly mean that. It's going to be hard for me to do in 4 or 5 minutes, but that's the plan. Then we're going to talk a bit about the 2019 SEC interpretive release on investment advisors' fiduciary duty, and then we're going to have just questions. I'm going to pose some, what I hope are some interesting and thoughtful questions to Mitch and to Bob, and hear what they have to say. I may chime in myself. And let me just add that I'd like for this session to be interactive. So normally in these kinds of sessions, we reserve 5 or 10 minutes for questions at the end. We're not going to do that here. We really welcome your questions throughout. If we say something that triggers something that you want to ask about, please raise your hand, jump in, speak up. That's really the way we want to run the panel. So I hope that works, and we welcome your participation. Okay, so investment advisors are fiduciaries. I could really stop there. That could be my entire introduction. The duty is not statutory, so it's very interesting. As most of you know, there's no fiduciary duty in the Advisors Act. In fact, it's really the opposite. Congress actually had, in one of the early drafts of the Investment Advisors Act, in some of the prefatory language, they had language identifying advisors as fiduciaries. That language came out of the final bill. So take that as you will. Some might say by negative implication, Congress was saying advisors are not fiduciaries because they pulled that language from the final bill. But indeed, there's no statement in the Advisors Act that says advisors are fiduciaries. Instead, the courts have interpreted the Advisors Act to impose a fiduciary duty on advisors. Even that is controversial. And the reason I say that is because the support for that proposition that the Advisors Act imposes a fiduciary duty really is quite questionable. We don't have time to get into that today, but that's no longer an issue because it is the law of the land, and nobody would dispute that. The Supreme Court, in a couple of cases, the Lowe case, has said that investment advisors are fiduciaries and that the Act imposes a fiduciary duty. And so regardless of what the academics have to say, once the Supreme Court makes the statement, there's no question that it is the law of the land, and nobody will dispute it. When we talk about fiduciary duty, we typically talk about 2 parts of the duty of loyalty and the duty of care, and you've heard people already refer to those this morning. The duty of loyalty, I say, is typically negative: no theft, no fraud, no self-dealing, right? That's what we generally mean by the duty of loyalty. The duty of care is typically a positive duty. What does a fiduciary have to do? They have to act with diligence, attention, and care. So in the Advisors Act context, the fiduciary duty often takes the form of a duty of disclosure, right? That's the typical mantra for fiduciary duties for investment advisors. We hear that and see that all the time. Again, another area of controversy. And the reason I say that is because lots and lots of academic studies have now taught us that disclosure, frankly, is not very effective. In fact, there's some interesting academic work that says that disclosure might have the opposite effect of what we want it to have. Once an advisor makes disclosure, some studies have shown the advisors then have a kind of legal license to engage in conduct that they might not otherwise engage in if they had not made the disclosure.
Although my study of clients say that clients desperately don't want to make disclosure, that they don't want they don't want their clients to read. So it does, at least in my practical experience, have an inter-arum effect that might not have been measured by those studies.
But disclosure is the theology of the Investment Advisors Act, and there's no question that we'll be talking about it.
Yeah, we're definitely in that church today, right here.
In that regard, I think the Advisors Act duty differs from the fiduciary duty under other statutes like ERISA, where there are some very clear prohibitions on conduct that cannot be disclosed around, right? ERISA makes clear that some transactions are just simply prohibited outright, and no amount of disclosure can change that. So there's lots of open questions about how to apply the fiduciary duty to advisors. Some of those, which we will discuss, are about whether the duty can be waived or limited. Some are about whether conflicts can be cured through disclosure and consent. Other questions are about whether conflicts have to be avoided in some cases, or at least mitigated.
One thing, between the Advisors Act assumes on the part of clients agency. The ERISA does not assume agency, and that's why and same like Investment Company Act, it does not assume that they can take care of themselves, they can negotiate or walk away from a deal. That's a fundamental difference.
So we are wrapping up my world's shortest introduction to fiduciary duty. I think we can really ask what what the fiduciary duty is for advisors. One way into that is to look at the 2019 SEC interpretive release on the standard of conduct for investment advisors, ask what it means for advisors, and indeed ask how investment advisors view their obligations as fiduciaries under the interpretation. So, one way to kind of get into that question is to ask the lawyers here with me whether the release has really caused them to kind of change their view, right? Change the advice that they give to clients, either in-house or in private practice. Once you read and digest the release, does that then change your advice? Does that change your view on the duties and obligations of advisors? So with that, I'd like to pose that question to both of you, and either one of you can jump in. Doesn't matter.
I'll start. First, I'll just give you a little background about myself, and I'm Mitch Gibbons. It's located in Houston, Texas. I've been practicing for 23 years and recently became the general counsel of an investment advisor, actually 4 investment advisors, $29 billion in assets under management, and a family office. And I'm finding that being now on the inside is giving me a new perspective on how to challenge, what we're otherwise saying as lawyers. So I find my role today is somewhat to bring our conversation back to the practical, and because I cannot challenge on the academic or the interpretation, because we've got long established and very well respected guidance here. So my role will really be to try to turn this on the practical, to see what we've seen in the industry and how we can really make some headway of this. On the question Arthur asks, I think that it was great to see a document that tried to take years and years of interpretations and put it into one document, so that you had one place where you could kind of point and say, no, here's where they say it again. I don't actually think that I felt like maybe it was too short, right? I thought that there was a lot more to say, and that it probably got parsed back. I don't know if someone else can tell us that, but it is, I think, helpful in that it does give us one place to somewhat look at something more recent, that they're repeating something, but that in the end, it was not the document I had hoped it could be, as far as something as helpful as it could have been.
It's really interesting for you to end there, because I say it's not the document I worried that it would be. After it went through the grinder at the commission and among the commissioners, it doesn't change. It has not affected one whit any advice I've given to any client since it's come out. And it's very happy, because I invested a lot of years prior to that document. I think the only time that's going to cite it is the commission cites it itself, and the commission enforcement guys do. And people in litigation will use parts of it if it benefits them or not. There's some things that are phrased a little wacky here and there, a little different than the common law sort of judicial approach. The difference between retail and institutional investors is one of those things, without defining what a retail or institutional investor is. The law is actually the reasonable investor. And that's a difference from the common law, because under the common law, you look to the client and whether the client actually knew and understood and consented. And under one of the changes in federal securities laws, you look to the reasonable investor, and that's way across the board from the federal securities law. So that's a difference. And of emphasis, although they phrased it to try to not make it is that, and I think people will use that. There's some other things that are a little different in terms of how they worded that will have that effect. People, again, will use it when it's better for their case and help their case, but I don't think counseling clients, it will change.
Well, if that's true, that might be a disappointment to some at the SEC. I don't know, but then the
No, I congratulate the SEC staff on
Well,
this. That's what they wanted.
The question, though, is then what then is the real impact of the release?
Oh, well, but it was a political exercise because they were doing Regulation BI, and remember after the broker-dealer wars, after 10 or 15 years, a plague on both of your houses, and so they both had to go through that exercise. And so it was an exercise designed to address a political need, and the question is, would they screw up the law in a meaningful way? And I congratulate the staff who worked on that and who supervised, because I think they didn't. It would not everywhere was said the way I would say it or the way I think it is better articulated, but I don't think not any of it really changed the nature of the duty as I understood it. It's a collage, basically, of things that have been said in the past, and some of the documents that they quote are ones that you and I worked on, Arthur.
So then let's dig into some of the issues that I think are definitely raised in the release, and I think it's issues that folks are grappling with a lot. So one of those issues is waiver, right? Waiver of fiduciary duties. The release says that an advisor's fiduciary duty, quote, follows the contours of the relationship, right? And then it goes on to say, right, the advisor and client can, quote, shape the relationship by agreement. That sounds like private ordering. That's private agreement. So the question then, does that mean that the advisor and client can also shape the fiduciary duty by agreement?
Yeah.
Is the fiduciary duty subject to contracting, and can some or all of those duties in some cases be waived?
Now, I think in parts of the release, this is one of them, where there's unfortunate wording in language, but other places that clarify it. I think Section 215A, you made reference to, says no duty under the statute. Any provision or contract purports to change any duty is void. So what I think the staff was trying to say here, and it does say at other places, is that the advisor's fiduciary duty depends upon the obligations, contractual obligations it has entered into on behalf of the contract. So it's not the nature of the duty, it's the scope of the duty. What are the scope of your responsibilities? If I'm actively managing a portfolio, I have ongoing responsibilities to manage that portfolio. If I enter into an advisory contract that says I reposition or rebalance your portfolio quarterly, I have a duty of care and duty of loyalty 4 times a year. That's it, by contract. And so you could see the nature of the duty of those 4 times a year is not any different than the advisor's ongoing management responsibilities. It's just limited to the scope of the duties of my obligations I've undertaken by contract.
I think the practical side of that is then when you start looking at what your contract says, you realize that there are some limitations you should have said, and then you go back and you have to correct those, right? We saw times where we're now saying, I don't take responsibility for voting your proxies. I don't take responsibility for filing your class actions, and a whole longer list of things where when you think about how often you do things and what the SEC might expect or what a client might infer you're going to do, you end up really wishing you could rewrite that contract to try to really specify what you're not doing versus what you are doing.
And the proxy voting release, which is cited several times in the 2019 release, speaks to that very issue. Mm-hmm. An advisor does not have a fiduciary obligation to vote proxies unless it undertakes to vote proxies. In that release, the commission said, however, if you have discretionary authority and your contract is silent, the commission will presume you've undertaken those responsibilities. So if you're not going to, be specific.
But just to bring this back, so for the lawyers in the room, 2062 suggests that an advisor has a fiduciary duty. We know that there's lots of enforcement cases brought against advisors alleging at a minimum a violation of 2062, and then 215, the other provision says any contract made in derogation of the statute is void. So to the extent that an advisor tries to waive its fiduciary duty 100%, that
So,
contract would be.
so if you say, I have a duty to vote proxies, but I have no responsibility, I'm able to vote them in my sole discretion on how I vote.
So,
That would be voidable.
so this question about waiver, I think, also raises a question about the status of hedge clauses, which also comes up in the release, in the interpretation. And in a footnote, the release says, and I won't read you the exact language, but it basically says something that appears circular. It seems to say hedge clauses cannot waive duties if the duties are non-waivable, right? There's this
Yeah.
kind of
Yeah.
circular footnote. And I don't know what to make of that, right? The language does not address the hard question as to which duties are waivable and under what circumstances. You have this, I'm sorry to say, somewhat circular footnote that doesn't really give much guidance. So
It's a-
anything about, can you
it's a
mention something
political
about
footnote.
hedge clauses? Yeah.
It's a footnote we had commissioners disagreeing on this issue. It's a hot button issue. They got comments on it. And the way sometimes you resolve things, either at the legislative level or at the commission level, is you write circular sentences and everybody thinks, hey, that's great. My sense is, Mitch, is that footnote didn't change the law at all. What it did, it pulled a letter called Heitman,
Yeah,
and in which said that the commission would evaluate the legitimacy of a hedge clause based upon the nature of the people to whom it is presented and whether they understand it. And the commission waived the Heitman letter, which everybody hated. That itched a particular political scratch.
Yeah.
Right there. And then went on to have two sentences explaining that they would the commission would look at the validity of these different depending upon retail or non-retail investors, which is a different way of saying exactly what Heitman said. And so Arthur's confusion is very well.
Yeah,
It's very
yeah.
well. So, but let me speak to now the larger issue, hedge clauses. The original issue is hedge clauses are unlawful. 215A, no doubt, you cannot waive a fiduciary duty. That has not changed and is not changed today. The SEC has never been deterred from bringing enforcement cases because somebody said, oh, I have a hedge clause. The duty under 2062 is based upon negligence standard. Now, 2061 is not non-negligence, 2062 is the one that's important. It's a negligence standard. And the SEC brings cases, and if anybody's ever tried to defend a case against the SEC on that, it doesn't even show up in the enforcement releases because the SEC will ignore you immediately. The SEC is not limited by your contractual provisions, which it did not agree to. So where the issue was back in the day was people would put these clauses in their agreement, and investors would think that they had no rights of action against a client under the federal laws, and that the SEC was fundamentally misleading. And then comes a case called Transamerica Mortgage, 1970, in that area,
In that area.
in that era, 1970 said, whoops, it reads just like 10b-5, which there's a private right of action, but we find there's no private right of action under the Advisors Act. So now, what does that hedge clause mean? Now that you don't have a right of action against the advisor under the Advisors Act, why wouldn't a hedge clause be perfectly okay? It wouldn't be misleading. It would be misleading. And then you get the Heitman letter, where the SEC, for reasons I've never quite been able to understand, couldn't bite that bone. Instead, they fudged on the issue a bit, and that's what we've been living with forever. But what the operation of the hedge clause does today, and I see them every day in my practice, it doesn't limit fiduciary obligations, as Arthur mentioned. It can't. What it does, and it's intended to do, is limit a client's ability to obtain damages for a breach of fiduciary duty. And since those damages can only be obtained under state law, they can't be obtained under federal law. To the extent they work to limit state law. And state laws are all over the place, both on whether there are damages, whether they would recognize an exculpatory clause, because in Delaware, if you're filing, it likely would. If you're filing under corporate law, say it's a private fund or a limited partnership in Delaware, clearly would. But there's 50 state laws out there, and people put them into their clauses hoping that they work.
I'm gonna bring it back down a little bit. Okay, so usually we have a training and it will say fiduciary duty. Realize that there doesn't have to be a loss to clients to have a breach of fiduciary duty. You can be liable and the SEC can come after you whether there's a loss to the clients or not. And then you say, oh, but there's no private right of action under the Advisors Act if there's a breach of fiduciary duty, and then you lose your audience somewhat, right? But there is, right? Under state law, under other arguments, and under the very broad interpretation of what is fiduciary duty, a lot of other things could come from that. The issue of what is a hedge clause and what are we talking about here? I think everyone will look at their agreements and they'll see that there is something in there that says we are not responsible for losses that may happen in your account, unless we are, found to be negligent, right? And normal losses in your account we're not liable for if it's within our scope of duty. And then there are bigger ones, especially in private funds where it says we're not liable and you will indemnify us and hold us harmless, for any losses or claims that come against us, unless it's gross negligence, right? Something like that. And so the difference is between something that just sort of says very, very broadly, we're not liable for anything, right? Versus we're only liable for things that are outside our fiduciary duty is something else. And I'll bring in one other thing that you'll also see in your agreement that kind of came from this Heitman era, which is you'll also see something that says, notwithstanding anything else we have in this agreement, nothing herein is a waiver of your rights under applicable federal, securities laws or ERISA. And many people thought it's okay that I have something overarching, overreaching, and kind of probably not enforceable as long as I have that other clause there. So where are we now
Well,
as far as
listen,
that
the
clause?
staff letter objected to those provisions also.
Yeah.
Hold on 1 second. So 2 things. First of all, I've got codes for you guys, right? So
Oh.
there's 2 codes throughout this panel. The first CLE or CE code, the word is Bluebird. Bluebird, that's our first code. Second thing I want to say quickly is this is a tough crowd to break in on. So if you've got questions, get my attention, just raise your hand, let me know that you've got questions, and hopefully, I'm blinded a bit by the light in the back, but hopefully I'll see you, and please just track me down. And as I say, we're happy to take questions throughout.
So the SEC has brought an enforcement case recently involving a hedge clause. It was really badly written, a hedge clause, and it has also issued the examination alert criticizing hedge clauses, but it included hedge clauses that purport to waive fiduciary responsibilities. I've not seen one of those. They see an awful lot of.
I have seen it. I've seen
Really,
it.
you've seen it?
Yeah, I've seen it.
Okay, the ones I see, and it exculpate liability, and that's a little bit different. And on top of this, most current event is the SEC has come out with proposals in the private fund area that would prohibit exculpatory clauses and indemnification arrangements that protect anything besides negligence, meaning they're imposing a negligence standard on the private fund industry. I know many of you may not be in the private fund industry, but I would expect to see a similar rule for the rest of the investment advisory industry down the road. The SEC has hinted in a couple of footnotes in that release that some of the stuff they're doing in there to hedge funds, they expect to expand to other financial service providers.
So both of you have raised issues about the scope of an advisor's fiduciary duty. That's obviously a key question. I want to talk first about the duty of care, and then maybe a question or two about the duty of loyalty. So with respect to the duty of care, the release has some language regarding a reasonable inquiry into a client's objectives. We're familiar with that concept. And a, quote, reasonable investigation into a particular security. But the release also says that the scope of the inquiry turns on facts and circumstances. Right? I'm always amazed when people talk about a facts and circumstances test, because that basically means there is no test, right? You just look at the facts and circumstances and make a decision. So the language arguably does not give much guidance.
Well, you're
So
right.
wait, hang on.
You're right.
So the question is, how is an advisor supposed to know how much inquiry is enough? I mean, this is a very interesting question. The amount of due diligence that an advisor could undertake is unlimited. Do they have to stop eating and drinking and sleeping because they're only doing due diligence? Or is 20 minutes? I mean, where does an advisor draw the line? How do we give some guidance?
95 to 98% of the cases the SEC brings have to do with duty of loyalty. The duty of care cases can fit into a bucket.
But they're critical for the day-to-day work of an
there is.
advisor.
And involves, instead of, I think, ERISA has a specific statement of duty of care of a professional in such a position. But do I think that changes in practice? I don't. I think it is the finder of fact looking at a particular set of circumstances and making a judgment whether under all of those circumstances the person has exercised appropriate care. Key, by the way, to control for this is how you hold yourself out as an advisor and the type of services you're providing. If all you're doing is asset allocation services, well, did you check up with the client once a year maybe to see if his situation has changed? That's perhaps the lowest level. On the other hand, if you're managing an option strategy, you better freaking know what you're doing and be on top of that every day. So I think that the lack of content in this release is not necessarily a problem. I would have phrased it slightly differently, Arthur, but I do not worry over that. I've not seen that. I've seen it come up in debates in enforcement cases, but ultimately the judges will say, listen, this is what you told your client. This was what was in your contract. This is what was on your website.
And Mitch, practical advice on the ground?
I think that there are a few egregious cases
Yes.
where recommendations were made about securities and absolutely no research was done that they could point to. I think the last time this was a very interesting question was around the Madoff period, where it was saying, well, you should have done more due diligence here. You said you do very thorough due diligence and you make these allocations. And that didn't seem to go anywhere, but it did place a lot more emphasis on how people are phrasing what they say they do, right? We've gone through and parsed out this, extraordinary, comprehensive evaluation of, everything to try to scale that back, to try to not give yourself more duty than you're obligated to do, which is the reasonable duty, right? I think everyone would say they do reasonable and probably a little bit more.
Back in the Madoff days at a conference just like this, I predicted that the Madoff, the law that would be developed in this area, not that, we wouldn't learn anything about Ponzi schemes that we didn't already know, but the law of the duty of care would be developed. I was wrong. I was wrong because the courts, the people that were involved in this settled, and there was never any there was not the discussion.
Challenge of
there was
it.
not a discussion that would have been, the tough cases that would have.
And what I recall, that there were some of these Madoff feeder fund
Right.
duty of care cases where the allegations were that the feeder fund should have done a lot more diligence into Madoff. And again, you all correct me if I'm wrong, my memory is that they were not successful. They generally, the plaintiffs that brought those cases, you're right, either settled, and some that were litigated just were not successful cases.
There was just no law developed.
Yeah.
That was,
Yeah.
something I could have put in my outline.
Right.
Nothing.
Right.
Nothing
Okay.
came of it.
So then just one or two things about the duty of loyalty. There was a little bit of controversy. I don't know if any of you remember this, between the proposing and the adopting release for advisors. The release says that an advisor cannot subordinate its client's interest to its own interest. That's the phraseology of the release. It cannot essentially place its own interest above the client's interest. This might sound technical, but the proposing release used a different formulation of placing the client's interest first, right? That's how the proposal came out with it, and then it was changed. Commissioner Jackson was opposed to that change. He gave a public statement and has spoken publicly about how he thinks that was a significant change. Question for you two is there a difference, right? Maybe if you're allocating a scarce investment to a client account and a proprietary account, is that, for example, an area where there's a difference between those two standards, or do you not see a difference between the proposal and the adopting?
God help us when the law professors get involved. Arthur did not sign the petition. A bunch of, I was pleased to see. I think this is angels dancing on the head of a pin. The SEC over the years has phrased the duty different ways at different times, but in the real world, cases don't turn on that issue. You never have, like, this is where it's 50% one way, 50% one way, who wins. That just doesn't happen.
But let's take Arthur's question, because I do think it's an interesting one, which is that, if you do have an allocation policy and your own proprietary accounts are part of that, allocation area or co-investments or the things like that, there's a difference between saying you can't subordinate your interests versus you'll act in the best interest of your clients, right? Because one could say, well, it's in our best interest to sort of allocate this fairly, and fairly includes everyone who may be involved, including our co-investment vehicle, versus you can't subordinate. If someone wanted to point to something and finally there's something to point to, right? Then maybe they would try to make a claim and say, no, you can't. That would be subordinating my interest above yours, right? So maybe it's something that could be pointed to if
So
someone.
this is what I do in
like you
class,
pointed
right? One
out.
student gives one point of view, another student's going to take the other point of view, and it's fun to get them going. So,
But yet,
Bob, do you have a reply?
yet in your case, it will probably turn not on the doctrine, but what the advisor disclosed in its brochure, and if it used the word fairly, or if I've never seen one that said I will not subordinate, but how it typically you see an allocation statement.
Fair and equitable over time.
Yeah, especially because if you're going to do your own accounts, you're required to, right?
Right.
So I think that those cases, it will turn on what you said, and that will turn it rather than, because in that case, if you said nothing and you were allocating resources to yourself, well, you've not made a disclosure. That doesn't matter whether you did it fairly or not. You failed to disclose. You had a conflict of interest, and you failed to disclose the conflict of interest.
So the practical takeaway on this one, I would say, is there are a lot of different places where you can fall into that disclosure issue, right? That there's, in your ADV, you're supposed to describe your conflicts of interest and your allocation policies and what you do to mitigate them. And sometimes you'll just say.
Address them.
Address them. And sometimes it says, well, something very broad, like we've got policies and procedures designed to, ensure that they're fair and equitable on an overall basis. And then you've got your code of ethics, where you've got these standards of care that has this fiduciary duty section in it, where that's usually where you'll find we put the interest of our clients first, right? Instead of always act in the best interest of our clients, or lots of other things that might be there that you might want to re-examine and see if that's the same as what you might have, versus then maybe sometimes you have them in your actual client agreement or marketing materials, or you might describe what those standards are and what you do. And it can all circle back to then,
And that's the importance of Part 2 and how it works into all of this. Part 2 changed dramatically some years ago to just state the facts and require clients to infer. Now it says to state the facts. It requires you to explain what the conflict is and how you address the conflict.
So let me ask about that. So let me ask about disclosure. So under the duty of loyalty, right, the release requires full and fair disclosure of all material facts. That comes from the capital gains case, now close to 60 years old, still the leading case in the advisors area. Full and fair disclosure of all material facts about the relationship. Moreover, Instruction 3 to ADV Part 2 says the advisor is a fiduciary and must make full disclosure to clients of all material facts relating to the advisory relationship. That is very strong language, right? That formulation is different from the other securities laws that really talk about prohibiting misstatements, you can't lie, right? And prohibiting omissions that are required to make other statements not misleading. Like that's the typical language. The scope of disclosure for advisors seems much broader than disclosure, say, by a public company, for example. Is that correct? And does that make a difference when you're advising clients on what kind of disclosure to make?
It does, because, disclosure, 33 Act disclosure to investors is designed to disclose information about a transaction that's occurring at the time and all material facts about the company related to that specific transaction. And under the 34 Act, transaction is an end to itself. The disclosure allows investors to have information to make trading decisions. And that's all the 33 Act and mostly the 34 Act does is disclosure, and then everything else afterwards. Advisors Act is differently. It's disclosure and consent. And disclosure is necessary, not just to satisfy Part 2, but to form a basis to allow a client to make a reasonable decision of whether to consent or whether to terminate or renegotiate the terms of the relationship. So so what I'd say, it's in a different context. And any of you represent private funds or involved with private funds, the disclosure and consent part, I spent an awful lot of time talking to clients about the consent part, because if you disclose to people, but they can't do anything, they don't have ability to consent, you haven't met the satisfactions under the Advisors Act. So in the private equity fund area, this is a non-liquid event. You can disclose things all you want to the fund or to the investors in the fund, but they can't do anything, and so you cannot infer consent. They have no ability to leave and depart, and so the private equity industry has developed this practice of having these limited partner committees, LPACs, which are representative of, which are typically the big player investors. And the commission in several enforcement cases has acknowledged that that could be a substitute because they consent to a particular conflict. The hedge fund industry, which is different, has liquidity events, say quarterly. And so what they do is they make disclosures to clients before a liquidity event and allow the liquidity event to pass and infer from the failure of their investors to redeem that they can infer consent.
So they like to get that disclosure out when performance is high and you don't want to get out.
Well, maybe, but what we really do is since they're tied into quarterly, they want to do it within like 45 days before the quarter end to give enough notice that they can infer consent.
Right.
Should there be challenge. So you can see the notice and consent, and that scope of that disclosure, I think, has to be understood in terms of what you're consenting to.
So 10 or 12 minutes left. Let me give you the second code just before I forget. I don't want everybody to leave the room.
It's like
and I don't give it to you.
advertisements.
That's my only job as moderator, is make sure that you get the codes. The second word is beneficial. Beneficial is the second word. So just following up on a couple of things that Bob mentioned about disclosure. One question that I've always thought about is, what are the implications on disclosure when, businesses are dynamic, right? The advisory business is always changing. Things are never standing still, or at least for the most part, they're not standing still. So what are the implications on disclosure that the advisor is making when the business changes, right? Must disclosure immediately also change, or can a kind of new business model that develops sort of squeeze into the old disclosure? Again, how does that work? I imagine that must come up fairly often.
I'll start on one thing that is just driving, I think, the industry crazy, which is you can't say any longer in your ADV that something may happen, right? If you've got plans, it's going to go this way or not, and that may happen, and this may expand, and the market may do this, and it may do that. Like we can't even prepare the client unless we use different words for this type of disclosure that may be very, very relevant to what might actually happen. So I think where we used to be able is to try to hedge our disclosure about things that might potentially happen so that we didn't have to run in and change it every single time. Now we are, I think, forced to make these adaptations so that everything is as precise as it can be, or use different language to help, predict that something might be expanding in that way.
So let me just say, let me ask, because you might have something to say about this.
I'm more specific to your question here. This is a question that comes up repeatedly with clients. To some extent, there's Form ADV has some issues in that, because like if you add a new fund, there's just an annual filing and it's not clear you have to make any disclosure. But generally speaking, it has to be material to the clients. And generally speaking, what I tell clients is there's a materiality question when you change your business. And if you disclose to clients, you get a get out of jail free client pass. So there's almost no cost to disclosing to clients. So when in doubt, disclose the change of business. Send out a notice. Many of you people can do it electronically, adding it, and it's you and go to bed and sleep soundly that night. Where people get in trouble is where something happens, it's material, and gee, we'll get to that in the annual report, or clients aren't going to like this. And that's where the role of the chief compliance officer and the general counsel. Unlike if you're an investment company where you have to go and file an exemptive application, or ERISA where they just tell you no all the time, the Advisors Act is a light touch statute. When
They
in,
can disclose to the client like in an email or a letter, but not refile the ADV except at the annual period?
well, I think, yes. Well, okay, that instruction that Arthur alluded to, instruction 3, really should tack it up on your wall. It also says that you have an opportunity to disclose to them information outside that document. The ADV is not like a prospectus, it's not the four corners of everything. ADV requires you to respond to the particular items, and if, because of a change of business, something in that brochure has become materially misleading, it's just wrong, except for the assets under management that can dealt with in years. Then you may have to change remend the brochure, and then there's a second decision: do I really need to send this out to everybody, or can I just send it to the new people? And those are issues. But let's just say your brochure is fine, or it's not materially misleading, but you still think this is information that is material to clients. Send them an email.
Like you add in an advisor throughout the year.
Yeah, and then although I don't know all the facts here, and then incorporate it into the brochure when you do your annual update. But you've got to think through first, because has my brochure become material false? But if it has, you got to change it, okay? But if it
So I'm glad we had a question. We have about
Great question.
7 or 8 minutes left. Normally, I would stop now and ask if there are questions from you all. As I said, we didn't follow that, but let me just pause and ask if there are questions. This is certainly a good time if somebody has. We've got more to discuss, but I just want to pause for a second and see if there are any other questions. Okay. So,
just discussion on May.
Yes,
May
yeah,
I?
about- yes.
I still think May can be used, but it has to be used with discernment, in which it has not been used before. If you have a list of things that you may invest in, and 98% are naked put options. I'm sorry, but the SEC had every right to sue that guy that did that. On the other hand, if you're talking about the different strategies, different things you're permitted to do in fulfillment of your major strategies down the road, and you're treated as permissive, but you're either not doing it, or if you do it, it's not going to be a significant part of what you're doing, it may be an appropriate place to use. The thing is, that's where you as lawyer and compliance officer has to be very careful, because the business people don't understand this. And that's where people get worked up, because let's say the strategy changes and something that says may, all of a sudden, it's the primary deal. And I think the SEC, and I was very concerned with the SEC when I was there, and some of this language about may is in releases that I helped write, is that we did see people trying to cover up or hide from investor clients things that they're really doing that they would prefer not to. So discernment.
Do you think, though, just changing the language satisfies that? Like, especially something like, this may create a conflict of interest, right? The litigators would say, don't say this does create a conflict of interest, because now you've just given them something that they wouldn't have otherwise. So if I say, well, this has the potential to create a conflict of interest, have I really solved the problem?
I think there's no such thing metaphysically as a potential conflict of interest. It is either a conflict of interest or it's not.
Yeah,
But there's
Mitch,
something close, right? There is something that doesn't like rise to the level of clear conflict of interest. But there's enough here that you're worried that it might be a conflict
Right.
of interest. You want to err on the side of kind of giving a disclosure, but you don't know how to word it.
So the question is, there's an element of risk-taking here, because everything is so fact-specific and everything is so dynamic. And, if you're the no-risk camp and you put, we do this, and then, of course, you don't do that, then you run into the business.
I'm good with that, yeah.
Mitch, that's very interesting. So when I saw that language, I thought the SEC was just saying, look, to the extent that you're doing X, Y, and Z, you can no longer say we may do X, Y, and Z, because you are doing X, Y, and Z. And that didn't used to be the case, so they
Right.
clarified that. But you're making a more subtle point, which is very interesting, and I agree that there might be some issues where it's unclear if it's a conflict of interest. Reasonable people can disagree, and so can one use that language to say that we may have a conflict of interest in this or that area when it's just unsure? I don't think that's what the SEC was getting at. I think they were getting at you're doing A, B, and C, and you're still disclosing that we may do A.
I think there are some consultants and some SEC examiners who are taking it to the limit.
I agree. I agree that's from, because I defend against that. But listen, this way, I may have a conflict of interest. The issue there, of course, is let's just say there's the SEC comes in or a private litigant comes in and sues, and now you're using that as your defense that I've disclosed it. And then somebody says, wait a minute, you just said may, or you just said potentially. That's not real defensive language. So now you have to defend that in ways that you may regret having used the qualifiers.
So your advice is that it's risky, if what you're trying to do is defend against risk anyway, just own it.
That's right. No, I exercise judgment because
Right.
the indiscriminate use of does or will or am can be as problematic as the indiscriminate use of may, but I still think may can be used appropriate and should be used may. It's just you've got to think through the issue. The larger debate is not whether may is possible, is that what under the circumstances is may appropriate in light of your duty to make full and honest disclosure.
So we don't have a lot of time, and I want to get to one question that I know is on, I've talked to folks, this is on their mind. It's this issue about mitigating or eliminating conflicts, which we touched on earlier. So the release states that in some cases, especially for retail clients, an advisor will not be able to disclose a conflict and will have to eliminate or mitigate the conflict. The question here is, how should an advisor draw the line, right, with that language? When is full and fair disclosure sufficient? And when must an advisor eliminate or mitigate the conflict and not rely on disclosure? This is, I think, a really critical area.
Well, disclosure, in the case of a duty of loyalty, disclosure, in my view, always, full and fair disclosure always addresses a conflict of issue. The SEC says, no, but it may not be always in the best interest of the client.
Right.
But that, of course, begs the question of who determines what's in the best interest of the client. The SEC examiner who comes in? No. That's not the way we do things in this country. An investor who's provided full and fair disclosure and consents, they get to determine what and the example I always like to give clients is a client comes and says, I want to use my brother-in-law to execute trades. And the advisor, I've actually had advisors call me with this thing, said, it's terrible. It's a two-bit broker. The client says, I know, but it makes my wife happy. I don't want to do it. Can he do it? Of course he can. And what you have is there's a conflict. There's a duty of care. If this advisor on his own decided to use this broker, it would be a violation of the duty of care. And it's a brother-in-law. Could it be a duty of loyalty violation also? But the client has consented. Lots of clients want to do dumb things. And I have seen a number of situations in which clients have wanted to come into advisory situation, which they're clearly not getting the best deal. The client, it's very interesting, who managed only charitable institutions' money. He made a bundle for them, and he had private clients come in, investors say, I want a piece of the action. And he was going to make a lot of money, but he didn't want to dilute the interests of his charitable clients, which was his first clients and his first love. So he set up a private fund just for these paying clients. And in that private fund, all of the investors, all of his clients, I'm not sure it was a private fund, agreed that the charitable organizations would get first dibs on all the IPOs, that they would take second place. And so any objective analysis of that situation, they were not getting the best deal, that his fiduciary duty would have been violated if he had just decided to do that. But these people went into the deal, had disclosed the deal with them, and still wanted to go to them. We, under the law, allow that to happen under the law, unless there's a specific rule on it. The staff was wrong on a number of reasons. They cited no cases to support that proposition, not a single ever enforcement case, and I've had them on a panel with me, and I've asked them, any cases? And then I've asked them, what kind of facts would you provide? What kind of situations would you consider bringing a case where there had been full and fair disclosure? No answer. Secondly, the statute, 2062, is an anti-fraud statute, and inherent in fraud under common law as brought into the Advisors Act is the notion of deception. underlying any accusation of fraud or any fraud has to be deception. But there's no deception. We're presuming full and fair disclosure. And so this is why I say that this release didn't change advice I give clients.
We're just about out of time.
Yeah,
Rich, any
the last
closing?
thing I would
Yeah.
say is I think the SEC is kind of coming to this idea, right, that you can't, if it's agreed upon and there's full consent, then it's not a fiduciary issue, it's not a anti-fraud issue. So I think in the latest private fund release, where they were saying there are some things that the fund investors cannot consent to.
Yes.
Right? That they're going to say it's a rule violation, right? So if they really don't like it, then they have to design a rule to say you can't consent away.
Right. And the commission has authority to do that under Section 206(4).
So I'm sorry for keeping you all a minute over. My students hate when I do that, rightfully so. I want to thank, I'd like to ask you to join me in thanking both of the panelists, Mitch and Bob. We don't want to stand between you and lunch, so thank you all for being here and hope you enjoyed it.